Hi, and welcome to SIGO's This and That. Join me, SIGO, as we explore the unsettling details surrounding unlawful detention, severe torture, and unsigned confessions. Are you ready to uncover the shocking truth behind Ntanzi's lawyer controversy? Was the Magistrate Cronje wrong by not being concerned about Ntanzi's 8 days detention without trial? Did Ntanzi voluntarily sign the confession statement? Did Advocate Mngomezulu poke holes into Magistrate Cronje's statement? Ntanzi's defense advocate Mngomezulu says his client was severely tortured and assaulted by police officers at 4 different locations before the alleged confession was made. Magistrate Cronje testified that Ntanzi informed her about his arrest on June 24, 2020, 8 days after he was taken into custody. Advocate Mngomezulu claims that Ntanzi was subjected to severe torture before the confession was obtained. Magistrate Cronje denies the allegations, stating that Ntanzi never mentioned being assaulted, only pointing to old scars and wounds. Mngomezulu alleges that Ntanzi did not sign or initial any pages of his alleged confession. Magistrate Cronje disputes this, asserting that Ntanzi signed on page 8 of the pro forma confession statement. Another issue raised by Advocate Mngomezulu is that Ntanzi was unlawfully detained for weeks without appearing in court. Ntanzi claims that he did not understand when he was supposed to appear and was never given a bail opportunity. Advocate Mngomezulu asserts that Ntanzi only appeared in court 3.5 months after his initial arrest. Magistrate Cronje admits that she did not ascertain if Ntanzi had been charged during their interaction. The cross-examination of Magistrate Cronje continues. Stay on until the end to uncover the jaw-dropping twist in Ntanzi's lawyer controversy.
May I just put it to you, as a person who has a legal expertise, that you were under a legal duty or obligation to explain the right to be presumed innocent until proven guilty, because the effect of taking a confession does not conclude his conviction. What is your comment?
I take note of the opinion.
Thank you. Let's proceed. Can you please assist me to read a provision relating to 48 hours? I think it's 35.3 if I'm not mistaken.
In artikel 35 subartikel 1 D Romeinse 1, to be brought before court as soon as reasonable possible, but not later than the 48 hours after the arrest. Unquote.
Lana-ke sichazwa-ke noma ufunda lana-ke ingxenye la ikhuluma khona-ke ngesikhathi umuntu akufanele-ke ayovela ngaso enkantolo ngaphambi emuva kokuthi eboshiwe.
The deponent or the accused, Mr. Ntanzi, was arrested on the 16th of June 2020 and brought to you on the 24th of June 2022. I'm talking about 8 days from the date of arrest. Do you know that?
Ek het dit ook opgemerk.
I also noted it or marked it as such. Nami-ke ngaqaphela-ke ngaleyo ndlela-ke ukuthi kwakusemuva kwamalanga awu-8 aboshwa-ke nkathi elethwa phambi kwami.
And when he was brought to you, that's my instruction, when he was brought to you to take a confession, he was not taken to court. He never appeared in court within 48 hours.
Ek het geen kennis of hy verskyn het of nie. Dit is nie binne my kennisveld gewees op daai stadium nie.
I have no knowledge as to whether he did go to court or not. It was not within my knowledge at that particular time. Ukuthi wayeyileke enkantolo noma akayanga-ke phambi kwemantshi angikwazi-ke lokho, akusiyona into engangiyazi ngaleso sikhathi leso.
In the normal course, when you are presiding as a magistrate, when an accused is brought after 48 hours, what normally happens in court for the benefit of the public? If a person is brought after 48 hours has lapsed, what normally happens? What is your decision as a magistrate?
Normaalweg persoonlik as landros in 'n strafhof hou ek 'n as artikel 342A ondersoek en verwyder die saak van die rol as die omstandighede dit noodsaak.
342A. Under normal circumstances, and I would then hold a section 342A inquiry, and if need be, I would then strike the case from the court roll. Uma ke kuyisidingo noma uma umuntu eletha ke phambi kwenkantolo emuva kwamahora awu-48 ngizothi ke ngenzeke noma ngifiseke ukuthi ngazi noma ke ngenze lokho akubiza ngokuthi inquiry ke yakhe section 342A uma kunesidingo ke lelo cala lelo ke ngilisuseke kuhla lwamacala enkantolo.
Thank you. My instruction is that Mr. Ntanzi was taken to court. First appearance of Mr. Ntanzi was on the 27th of October 2020.
Ek dra geen kennis daarvan nie.
I have no knowledge of that. Ukuthi ke waqala ukuya ngqa enkantolo ngezi 27 October 2020 angikwazi lokho.
The question, as per the previous question, as per the previous answer you gave, if Mr. Ntanzi was brought before you as a magistrate on the 27th of October, if he was arrested on the 16th of June, you would strike the matter of the roll. Is that correct?
Ek sal eers 'n ondersoek doen in terme van artikel 342A, aangesien ek geen sake kan verwyder van die rol sonder sodanige ondersoek nie.
I would first have held the inquiry, the section 342A inquiry. I cannot just remove a case or strike a case off the roll without such an inquiry. Uma kuukuthi ke wayevela phambi kwami ngazo lezo 27 ka-October 2020 kube ke yena ke waboshwa ziwu-16 June 2020 bengeke nje ngese icala ngilisuleke kodwa bengizoqala ngifuna ukwazi ukuthi kwakungani.
From the version of the accused to say his first appearance was on the 27th of October 2020 and he was arrested on the 16th. According to this version, it was not a reasonable time for him to be brought to court. Do you agree?
Ek het nie al die feite.
Yes, my lord. I think it's wrong for my learned friend to put a question that is not correct to the witness. He's in possession of proceedings in other cases, and unless he specifies his question, that question that is put into the witness is not correct.
For clarity, I'm referring to this specific case. I'm referring to this matter.
Advokaat, ek kan net gaan op die woord van u kliënt toe hy gesê het hy is op die 16de gearresteer.
Advocate, I can only take or go based on your client's word or what the client told me that he was arrested on the 16th of June 2020. Mina ke ngingathatha nje kuphela lokho engalitshelwa ke ulo omele ukuthi waboshwa nge-16th ka June 2020.
Ek kan nie sê of hy op hierdie saak gearresteer was of op 'n ander saak nie. Ek weet nie wanneer hy verskyn het op wat nie en ek weet ook nie wanneer hy verskyn het op hierdie saak nie.
And I cannot tell as to whether he was arrested on that date on this particular matter or on another matter, and I cannot say when he did not appear or which matter.
I'll leave that for a moment, ma'am. Let's just proceed on something else. May I proceed to ask the following question? This is the pro forma. This is the statement. These are attachments. I'm referring to the copies of the IDs of the officers. Does that all this constitute a confession?
Die verklaring ten opsigte van die konfessie self is aangeheg, maar die voorvereistes om te kom tot daai verklaring is ook aangeheg.
Okay. The statement is also the statement is attached together with the requirements to get to that particular statement. Istatement lesi kanye nalokho okufunekayo noma okudingekayo ukuthi uyofika kusona ke istatement kuhlanganisiwe.
Die verklaring sluit met ander woorde my bevinding in na aanleiding van die vrae wat gevra is, die antwoorde wat gegee is.
Now that then includes, that is now my finding with regards to the questions that I posed as well as the answers that were given. Lokho kokufaka phakathi ke imibuzo engayibuza kanye futhi neimpendulo engayithola nesinqumo engafinyelela kusona.
My question will be,
Dit vorm saam 'n deel van die verklaring in terme van artikel 217.
It then forms part of the statement in terms of section 217. Kube kusuba yingxenye ke yaso ke istatement lesi ke statement esenzwe phansi kwakhe ke section 217.
Maar die bekentenis self ten opsigte van wat die deposant vir my gesê het ten opsigte van die misdaad is net ten opsigte van aanhangsel A.
But then the statement with regards to what it is that the deponent informed me with regards to the commission of the offense itself is then annexure A. Kuse kuthi ke sona ke istatement lesi la khona ke engichazela kona ke ukuthi yini impela eyenzeka mayela ke necala leli bona ke bese kuba annexure A.
Die bekentenis self is dis 'n annexure A, maar die hele dokument sluit die verrigtinge in totaliteit in.
The confession itself is annexure A, but the entire document is contains the proceedings as a whole. Bese kuthi yona ke i-confession lena noma istatement lesawasenza kuba annexure A, kodwa ke uma usuwahlanganisa ewonke ke kufaka konke okwenzeka ngaleli yalanga.
okay. So I just want clarity. Annexure A consists of 6 pages, 1 to 6. Is that so?
Dis korrek.
That is correct. Annexure A ke ama page awu 6 1 yofika ku 6.
From that statement, that is the statement of the confessor or the deponent. Is that correct?
Dis korrek.
That is correct. Futhi lesa statement ke statement esalona ke owayekhuluma kumina engitshela.
For the benefit of the public, was it supposed to be commissioned, signed and commissioned before a commission of oath?
Nee.
No. Kwangafaneleke ukuthi sibe sasayinwa ke sisiwe ke kumuntu obizwa ngokuthi commissioner ke ozobeka ke istem.
Was the statement signed?
Ja.
Yes, yebo statement esasayinwa.
All right. May I approach my colleague?
Yes, yes.
My lord. Are you in possession of the statement?
Yeah.
Dis korrek.
That is correct.
Can we go to the last page? I think page 6 of the statement. Page 6 of the statement. Are you there?
Dis korrek.
That is correct.
Do you see the signature of the deponent?
Hy het hier sy initial gemaak, die volle handtekening verskyn op bladsy 8. Nadat die verrigtinge voltooi is, het ek hom versoek om die volle handtekening te maak op die laaste bladsy wat bladsy 8 was van hierdie en dan het ons almal geteken.
It's only his initials that appear there, but his full signature is on page 8. That's when everything was now completed, when I requested him to sign, and we all signed. ukuthi ke asayindeke akasayindanga lapha kule page 6 wabeka njena ke ama initials akhe kwase ukuthi ke page 8 page lokugcina ke ila khona ke singamcela ukuthi asayinde mase qedwe konke nathi ke sase siyasayinda.
All right. From page 1, if I may ask you to peruse it, peruse from page 1 up to page 5. Do you see any signature of the deponent?
No, it's only his initials. Akasayindanga ku page 1 yofika ku page 5 ukuthi nje ubeka nje ama initials akhe.
My instruction is that he has never or did not attach any initials, and he did not sign any statement, especially in front of you.
Dis 'n formulian.
That is a lie. Amanga nje lawo ukuthi nje akakazi asayindeke phambi kwami noma ke abekeke ama initials akhe.
Sorry, I'm not interfering with your interpretation. So you said it is an familian.
Dis correct.
Can you just say it in English?
Infama.
It's an absolute lie.
It's a notorious lie.
Yes.
You said he signed on page 8.
Dis correct.
That is correct.
Page 8 is a pro forma.
Dis correct.
That is correct.
It's not a statement.
Dis correct.
That is correct. Kuqiniswa ukuthi ngithe usayine ku page 8 nokuthi ke kuyi performer ke akusona istatement.
A statement is separate from a pro forma. A pro forma is to insulate an inquiry before making a statement. Is that so? In which the signature of the deponent appears in the statement. Do you see that?
Ek neem kennis.
I take notes.
So the statement, you see that there's a pro forma and a statement.
Ek sien dit.
I see that. Ngiyabona ke ukuthi kune form ke lokubizwa ukuthi performer kanye ne statement.
In that statement, there is a thumbprint from each and every page. Do you confirm that? If not all pages, but there's a thumbprint in that
Ek is net
statement.
besig om te kyk as jy maar net die geleentheid sal gun.
Just give me an opportunity. I'm busy checking.
Ek sien die duimafdruk.
I see the thumbprint. Ngiyasibona ke isithupha lesi esibekiwe.
Do you see the initials at the bottom of the first page of the statement?
Ek sien daar's 'n geskribbel.
I see that it's scribbled there. Ngiyabona ke khona nje kubhaliwe lapha yana.
Daar lyk soos 'n handtekening langs die duimafdruk en dan lyk daar soos 'n of dit 'n O of 'n Q of 'n X is en dan nog so 'n skribbel. So ek kan nie sê of dit 'n handtekening of 'n initial is nie.
I see
En of
that.
dit net 'n maak is nie.
I see that there's something that looks or appears like a signature next to the thumbprint, and then there's something that looks like an O, a Q, or an X, and then there's another scribble. I cannot confirm as to whether that's a signature.
Now let's go to the last page of that statement. What do you see there? Last page.
Watse deel
Which part?
Watse deel verwys u nou na?
Which part are you referring to?
The last page of the statement.
Van die konfessie.
Yeah.
Ja.
What do you see there?
Dieselfde geskribbel.
There's the same scribble. Ngibona nje lo mbhalo ofanayo.
En bo dit verskyn signature of justice of peace.
And then on top of that it appears the signature. Sorry?
Ekskuus. Onder die geskribbels verskyn dit the signature of Justice of the Peace in die volle name.
Just underneath that scribbling, then appears the signature of Justice of the Peace as well as the full names. Amagama ke alowo ke kuthiwa uyena ke wayithatha amagama akhe aphelele.
En heel onderaan is daar weer 'n duimafdruk.
And once again, right at the bottom, there's another thumbprint. Phinde ke ezantsi kube nesithupha
Met 'n ander handteken.
with another signature.
So there, do you see the signature of the deponent on the same page?
Nee, want hier's net 'n duimafdruk. So ek twyfel sterk dat iemand van die Justice of the Peace of sy kantoor het met 'n duimafdruk gaan teken. So ek kan nie vir u sê wie se handtekening is wie se nie.
Okay, so
No, it's
Of wie
only,
se merk is wie se of wie se duimafdruk is hierso.
it's only a thumbprint, and I doubt strongly that a Justice of the Peace would then just put a thumbprint. So I cannot confirm which signature belonged to who here from that which appears here. Ngibona nje isithupha lana futhi ke ngiyangabaza ukuthi ke umuntu ke uyena ke owayethatha statement kungawuyena ke ongabeka isithupha. Ngeke ngisho ukuthi le signature ngibona la ukuthi ekabani.
may I rephrase it? May I rephrase my question? The signature that appears on behalf of the words Justice of Peace, other than that signature, is there any signature on that page that you see?
Daar is 'n handtekening net bo die thumbprint.
There is
Duimafdruk of ek weet nie wat se vinger hier af vingerafdruk is nie. Duim, voorvinger, middelvinger, ek weet nie.
there's a signature just above the thumbprint. I cannot say it's the thumbprint, it's the middle finger, or which finger it is, but there is a signature above that.
Normaalweg behoort daar geskryf te wees wat se vingerafdruk daar gevat is.
Normally it should be indicated there as to which particular finger was taken. Kufanele ngenjwayelo ke kuvamise ukuthi ke kubhalwe ke ukuthi imuphi umunwe loyana obekiwe lapha.
Ek vind dit ook onwaarskynlik dat 'n getuie 'n thumbprint sal gee. So ek weet nie of die handtekening by hierdie vingerafdruk dien as 'n getuie tot wie se vingerafdruk gevat is of nie.
I also find that for me it would be improbable that a witness would put his thumbprint, and now there is a signature next to that thumbprint. I don't know whether that is now to witness as to whose finger that is printed on there. Nokuthi futhi ke ufakazi angathi abesebeka isithupha sakhe ke naloko ke kuyinto engilabazisayo, nokuthi futhi kube sekuyasayindwa ke eduze kwaleso sithupha leso ngazi nokuthi lo muntu uyasho noma uchaza ukuthi umunwe kabani lo ya.
So u vra my met alle respek om op hierdie stadium te spekuleer op wie se vingerafdruk is hier en wie se handtekening is hier. Ek neem aan die handtekening wat lyk soos 'n Q en 'n X en daar geskribbel is die Justice of the Peace. Dit is die vrederegter se handtekening bloot op feit dat op die laaste bladsy daai selfde handtekening bo die lyntjie verskyn waaronder getik is Justice of the Peace signature.
And with all due respect, now you are asking me to speculate with regards to this, and but where there's that scribble, I just assume that that one would be now a signature belonging to the Justice of the Peace, because if you look at the last page, just above where it's written signature of Justice of the Peace, that signature is above that. Lana ke umcela nje noma uthi kumina ke angicabangele nje noma ngiqageleke ukuthi ubani obesayinda la ubani obebeka isithupha, kodwa ke la kungathi khona ke kunale umbhalo ongathi u-O u-Q noma u-X, ngicabanga ukuthi yilona ke owayethatha istatement lesi.
So ma'am, the purpose of this exercise, the reason for giving you that statement is to compare your statement and the statement that is in front of you, that they are different, totally different.
Nee, met alle respek, ek weet nie wat u wil vergelyk en hoe sê u dit is verskillend nie. Hierso het die persoon die verklaring onderteken met 'n duimafdruk.
I don't know what it is that you find to be different and what it is that you want to compare, because here a person made a statement and confirmed that with a thumbprint.
In my verklaring is dit bevestig deur die deposant by wyse van initial.
And in my statement, it was then confirmed by the deponent by means of initialing.
So die deposante in hierdie geval het verskillende maniere gebruik om die verklaring te onderteken, of dit 'n merk is, 'n handtekening is of 'n duimafdruk is.
Now, in these two different statements, the deponents made use of different means to confirm their statements, whether it's by a mark, by a signature, or by a thumbprint.
Ma'am, sorry, please, can I afford me to ask a question? This is your statement. This is the statement that was made in front of you. This one.
Dis korrek.
Dat is
Dit is
correct.
bladsy
6.
15. Dit is met ander woorde 6 van 6 hieronder. Jy sal sien heel bo by my dokumente het ek dit basies so gemerk.
You just see it right at the top in my documents. That's how I marked them. That is now that would be page 6.
Yes,
Page 6.
Bladsy 6 of 6.
that's correct.
6 of 6.
That's why I'm saying there's no signature of the deponent. Do
Nee,
you
maar ons
agree?
het steeds 'n initial hier. So of hy nou sy thumbprint daar gesit het, volgeteken het, 'n kruisie gemaak het, sy neusafdruk gesit het, hy het dit onderteken.
But now there is an initial here. Whether he initialed, he put a cross, a thumbprint, or his nose print, but he did put something there. Lana ke ukuthi ke akasayindile, kodwa ke ubekile ke ama initials wakhe, noma ke bekuyikhala libekile, noma isithupha sibekile, noma wenze a cross.
I'm not talking about the initials. I'm talking about the signature. What is important is to inform the court that the statement was never signed. There's no signature of the deponent here. In page 6.
Nee, daar's nie 'n wetlike vereiste dat hy sy volle handtekening moet gee op hierdie stadium daar nie. Hierso is en ek weet nie eens wie dit gedoen het nie. U wys vir my 'n bekentenis. Ek weet nie wie se bekentenis dit is nie. U wys vir my 'n bekentenis vrede regter met 'n duimafdruk. U is tevrede met daai duimafdruk. Maar u het 'n beswaar omdat 'n persoon nie in hierdie konfessie of bekentenis van my 'n volle handtekening gemaak het nie.
Yes, you are showing to me, firstly, there is no legal requirement for a person to do that. You are showing me here a statement where a person has put down a thumbprint and you are satisfied with that. On my side, a person initialed and you are not satisfied with that.
Thank
you
you.
are satisfied with the thumbprint.
Mits ek u verkeerd verstaan as jy dit net kan duidelik stel.
Maybe I misunderstood you. If you can just put it correctly or much clearer.
Can you interpret it, miss?
Which part now?
All right, may I rephrase the questions? Let's just rephrase the question. My question, very simple. At the end of the statement, page 6, last page of the statement that you have taken, other than the alleged initials, there is no signature of the deponent. That's what I'm asking.
Daar is nie 'n volle handtekening van die deposant nie. U is heeltemal 100% reg.
100% correct. There is no signature of the full signature of the deponent. Uqinisile ukuthi ku page 6 kulesi sami statement ayikho noma akasayindile ngokugcwele.
May I have that statement, please? Thank you very much on that exercise.
Are you not handing out that document?
Sorry, ma'am.
Are you not handing out that document?
No, man.
What's the value then of that if the court can't even see it?
Somebody's coming to testify on that statement, man.
That's not the point. This is the witness who's being cross-examined on the two documents, that document. And I'm saying, are you not handing it up? That's all of it.
I'm sorry, my lord, the time annexures were handed to the court. It's one of the annexures. I just want to confirm because I was not present
Okay.
at that time. It's marked J. What? It's marked. H, my lord.
H.
So it's just a pro forma, my lord, I beg your pardon, because the statement is part of the redacted parts. So may I reserve that for my argument in the event a statement will...
Reserve handing up the document.
It's just that your lordship will not have sight of the statement at
That's
the moment.
correct.
But if the court is inclined to look just at the back of the, just for the purpose of the exercise, to compare the last page of the statement attached under HH and the statement attached under JJ, only the last part of the statement, not on the contents of the...
I see your colleague there smiling. Mr. Louis.
We are of the view that the entire document must be handed up.
No. Rather, let me withdraw that question.
And the document. Because
And
the
that
handing up of the document, sorry, sir.
And my lord,
The handing up of the document is predicated in support of your cross-examination of this witness, where you said he must compare, she must compare the two documents, that is Exhibit JJ,
and
as she explained it, and the facsimile, which you say she must compare her confession together with the attachments or the annexures to that very facsimile which you have handed over to her.
my lord, the issue is that a statement cannot, as per agreement,
With whom? With whom?
between the parties,
Oh, the state.
yes, that it cannot be handed over prior to the ruling. In
No,
terms of
I'm
the
aware of that.
Yes.
But that's that statement, the one which you say belongs to some other person.
Yes.
Why can't this court have sight of it? Because you are using it for comparative reasons, are you not?
I am, my lord.
Yes, I'm aware. So you are saying you are withdrawing the question now.
Because when I'm consulting with my colleagues here, I was not part of what was discussed. But if they discourage me to hand over the last page, because I indicated that only the last page for the sake of comparison, because it consists of certain parts of the statement. So that is the fear that my colleagues have, for the court to have sight of.
Yeah, this is a danger you undergo when you use a document which can only be disclosed to viewing after the court has, if it has, or if it does rule that that statement was made freely and voluntarily, etc. You are the one who opens the can of worms.
No, it's fine.
And yet you, all of you, you refused me to listen to an audio recording.
It's not
Now
us.
you want me to view a statement, the statement.
My lord, is the law. It's not us. May I withdraw this?
No, it's your choice.
May I would like to withdraw it, but that will be subject of my argument. May I withdraw the last part of my question in relation to the...
So the last part of your question is withdrawn.
On page 6 of the accused statement.
Okay.
But I'm happy that the witness has confirmed that there's no signature of the deponent.
The cross-examination of Magistrate Cronje continues. Thanks for watching, and don't forget to subscribe to our channel for more updates on this case and others like it. Till then, I love you guys.